Mr. LaVan, we welcome you this afternoon.
Thank you.
You are the last person, but you're not the least, so I don't want you to get worried about that. And we're ready for your opening statement.
Okay. Well, thank you. And I know it's been a long day already, so I'm going to at least try to maybe approach this just a little bit differently. And I appreciate each and every one of your time and your consideration and on all your efforts that you put into selecting the best candidates for the Iowa Supreme Court. First of all, I'm going to start with why I'm in the practice of law, so that you get to know who I am and my heart with regard to the entire legal system. I also want to address how my experiences hopefully have uniquely prepared me and distinguishes me out of the many experienced applicants that you've already heard from today, and will continue to interview yet this week. I hope to show you that I indeed possess the integrity, the legal knowledge and ability, the professional experience, the temperament, the communication skills, the diligence, the commitment to public service, and the leadership skills for this position. First of all, I want to go back to how it is or why it is that I became a lawyer and practiced law. It all went back to when I was a teenager. And a good friend of the family of mine and my dad's lawyer, Steve Hamilton from Storm Lake, took me in as a young teenager and brought me into his law office as a runner and to help him out and to show me what the practice of law was, because I had an interest in what that was like. And that was kind of the introduction to the practice of law. And I always had this idea that I wanted to do some public service or that I wanted to serve in the FBI. And so being from a family that grew up in northwest Iowa with very little means to afford college, nobody in my family had gone to college, and my draw to the public service, I went to the Army Reserve recruiter, and I told him I needed money for college, I wanted to go to law school, and I needed to, I wanted something that would get me into the FBI. And so he informed me that, hey, there's this military intelligence thing, but he never really put anybody in it. And that I would have to go and take a 2-day type of exam and see if I could be placed in military intelligence. I took that exam, and they offered me any position I wanted, so I said I wanted the one with the most money so I could go to college and law school. They gave that to me, and at 17 years old, I went off into the military intelligence and went through military intelligence school. Now, there was 63 of us that started that school, and there was 13 of us that graduated. They also challenged us. There was apparently had been 2 or 3 years since anyone had gotten a perfect score on one of the exams that took 2 to 3 days to do. And so if you got 100% on a perfect score on that exam, they'd give you an Army Achievement Medal. I have that Army Achievement Medal. I also graduated in the top of that class. I can't go into the specifics of military intelligence, but I just want to say that being part of the intelligence for 9 years and what's prepared me well for, I think, this position in the Supreme Court is that in the intelligence you get a lot of information. You get a lot of data, and you need to sort through it all and find which ones are the real issues and which one's the real information that you need to come up with the answers or the solutions to what you're looking for. You look at all the views when the intelligence comes in too, so that you're trying to find all the different issues, and you look at it from this way and that way and every other way. And then you prepare a lot of reports and a lot of briefs, and you do briefings. And I have done all of those things, and I think it's a great training ground not only for integrity, diligence, but leadership. When I went to college, I ended up taking college courses in high school. I was one of the first few students that had enrolled into the pilot program that allowed you to take college courses while in high school. And so my first college courses was while I was in high school yet, and I took them at the community college in Spencer, Iowa. Then I went on to Mankato State University, now named Minnesota State University. I graduated magna cum laude, political science, again pre-law. I also had a double major. I also graduated with public administration degree and a minor in law enforcement. And I think that the administration side, the coursework and I'll get to it, some experience in the administration side will be helpful overall with regard to the administration part of the role of a Supreme Court Justice. I went on to law school at Drake. I graduated with honors. I had the privilege of doing several law clerkships while in law school, and I'm gratefully indebted to all the attorneys that worked with me and participated in those clerkships. I also, after law school, stayed in the military but served instead from the military intelligence. I went into and was a JAG officer for 3.5 years or so. There's a letter of recommendation from a judge and Colonel Tobin that I served with as a JAG officer in my file, and hopefully all of you have received that. Then as a practicing attorney, I'm both licensed in Iowa and in Florida, and I took both bar exams. And so I've had the opportunity to practice law when I first started at LaMarca and Landry in some great and unique opportunities, both here in Iowa and in Florida. And so I do have a broad range of civil experience in business and commercial litigation, construction, insurance areas, employment laws, class actions, securities litigation. Most of those, instead of being in front of the court, was in front of the old NSD, now FINRA. There's a letter in the file, hopefully that you would have from George LaMarca, my former employer, which I think shows perhaps not only my propensity for abilities to do trial work and my experience at that firm, but also with regard to my temperament, because a lot of times we know how law firms end when one leaves another firm, but mine was a great experience. And so I'm thankful for all of my opportunities and the work that I had at LaMarca and Landry. And I know that your time's valuable, and so I did ask that only a handful of recommendations be sent in to you, ones that were hopefully truly meaningful and that you could review. I know that some of them were from clients, some were from my colleagues, some were from nonprofit organizations. I believe one was even sent in by an FBI agent. One was a neighbor of mine down the road, which sent in a letter of recommendation after he saw my name published in the Des Moines Register. And I believe even Craig Paulson, the Speaker of the House, either has or will be submitting a letter of recommendation on my behalf. I say this because I want you to hear my heart for the justice system and who I am as an attorney. The letter from my neighbor was because I like to help my neighbors. When there was a crisis that came up in our area with regard to the threat of the Raccoon River Valley and the neighbors' properties, I stepped up and helped organize the commission and was helping them with regard to organizing on what to do with that entire situation, and so that's what that letter of recommendation is about. I volunteer my time with regard to the nonprofit organizations a lot in the area of education, and I volunteer to help children for the last 10 years. I do that for no remuneration, just rather it's because it's something I enjoy doing. It's the way that I can use my education, my skills as an attorney to help out and give back. I worked closely with the legislature during that time when I worked with the nonprofit organizations. I helped draft legislation and help watch legislation and work through the process on both sides of the aisles. And so I think all of these things culminate to an experience and a background and the depth that's needed for the position on the court. I just do want to just make one other comment with regard to, you probably have read about my significant cases that I put in my application and I referenced. I do want to say that I tried to choose a wide variety of what are significant to me and then what was significant in writing samples. And so if you have any questions about them, I'd welcome them here after my opening remarks. All of this to say that, I am a student of the law. I have a heart for justice. And if selected, I would work hard to move the court away from discussions of impeachment and other harmful rhetoric to the justice system. And I'd appreciate your serious consideration and opportunity to serve first the people of Iowa, to serve the judges, and to serve the court personnel in this position. Thank you.
Thank you, Mr. LaVan. Let's start on this side of the table. Any questions? Mr. Cook?
Sir, I see in your materials that you were a major contributor to a treatise called Iowa Pleadings and Causes of Action and Defenses by Mr. George Lamarca. And he relied upon your scholarship and work, I trust, to produce that treatise. Tell us your view on how a court should reach the appropriate balance between stability in the law and development of the law.
The appropriate balance between stability of the law and the balance of the law, is that
Development of the law.
development of the law? You know, that's a good question. I'm not sure that we have enough time to maybe perhaps dive into all of that. That question's pretty broad. You want to narrow it down as to a specific area that you're really thinking about, or?
Well, what I'm most interested in is the courts try to follow the law that exists, and as cases come forward, there may be developments in the law or expansion of the law. And what I'd like to know is your general opinion on the balance between those two tasks.
Mm-hmm. Sure. Perhaps maybe what you're getting to is, my overall judicial philosophy with regard to looking into those particular laws. I tend to lean more on the side of judicial restraint, in the sense of what Justice Oliver Wendell Holmes had written in his dissent in the Lochner opinion, and that is that we look at first of all, you presume that the statute or the law that's passed by that legislature is valid and that they passed it constitutionally. So the burden of proof is on the other side that's challenging it. And then you look at it and you would have to determine, is there any aspect of it itself that you can declare, that part's unconstitutional, but you remain you try to leave the rest intact to the extent as possible. And I'm speaking broadly here, so I don't know how you would, unless you have a specific case in front of you, you approach each one based upon the facts and the law. But those would be sort of my initial opinions on that.
Mr. Brody?
Welcome, and thank you for being the last one tonight. I also want to note that it's rare when you have two seedsmen in a room and a room full of lawyers and a judge when we're not going at it with each other. So thank you for that. Basic question is, maybe it's along the lines of what Guy was going after, but when you've had an issue, either through your practice or in your personal life, that where you had a philosophical or a challenge to your core beliefs, how have you worked through that? And do you have an example of that?
Mm-hmm. Whether or not I've ever had a case that challenges my core beliefs.
Your personal beliefs, your personal philosophies. And then it did not be a case, just another matter where you may have been thinking a little bit differently than what was presented with you, and you had some duty and obligations to fulfill.
Well, I guess what comes to my mind right now is that I had one situation where I was at in my old firm where I was asked to represent a client and a client's interest in the area of gaming and gambling, and it was actually directly. It impacted me personally, not necessarily where I was at on core beliefs, because the gaming and gambling casinos was looking at putting a casino right outside of the intersection that I exit on and go on every day to my house. So it was more of a personal issue about whether or not I was willing to represent the client in favor of trying to get that done. And I refused to do so on the basis that I just felt like I was too conflicted. I couldn't represent the client and what the client needed to do. And so somebody else in the firm took that on and represented that client.
So is that how you would normally approach things, by saying, I can support this, or I can work on this, or I can't? I mean...
Well, in that particular situation, I think I was ethically bound to indicate that I couldn't represent the client zealously and appropriately. I've never really had any other situation come up where I would have to say, based on my core beliefs, that I could not represent that client appropriately.
Thank you.
Any other questions to the left here? How about on the right side of the table? Let's start with Ms. Walker.
Thank you for coming, Mr. LaVan. You were quoted as saying that the court has usurped God's authority and that there was a discussion of God's law. And I guess my question is it your position that there's another law other than the Constitution and the statutes of the state that the court is obligated to consider when making decisions? And I guess if so, where's that found and how does that weave in with the Constitution and the statutes?
Your question is whether or not there's another law above the Constitution and the statutes of the state of Iowa.
If that's your, I guess I'm asking if that's your position because that's my understanding of the way you stated it. And so then if that is your position, can you tell me how that factors into the court's decision and where that would be found for attorneys to consider that if they're going to appear in front of the court?
Well, I do believe there is God's law. I mean, now you're getting into my faith and belief system as a Christian and my core beliefs. And God's law is found in the Bible. And so as a Christian, I'm bound to follow to the best of my ability and by God's grace and forgiveness when I fail, the laws of God and His Word. Now, how does that apply in my decisions to a court, perhaps is where you're trying to go with this?
I guess, just for clarification, I'm just asking, I guess, if you were to be a justice, does that ability affect how your decision-making, I mean, do you think that affects how you're going to make decision-making over the Constitution and the statutes, or do you think as a justice you're obligated to only follow the law as written in the state? And I'm not saying as your religious beliefs necessary. I guess I'm asking if there's a separate body of law that you feel you're obligated or that would affect your decision-making with regard to the laws of the state.
I think all of us, if we're honest, will say that our backgrounds, our experiences, and our beliefs are going to somewhat impact some of the decisions that we make. However, I would like to say that, as the cases come in front of me, that I'm going to be looking at the facts and the law, and you would be interpreting the Constitution and the statutes in accordance to where the laws and the facts allow you to go. And so I don't know that I'd be, if you're asking if I'd be writing opinions that would be citing God's law into them, I just don't foresee that, as being something that you would be referencing as a basis for your decision.
Any other questions down this way? Mr. Fitzgibbons?
Thank you. Mr. LaVan, thank you for being our last interviewee today, and thank you for coming all the way up to Esterville to visit with me. I appreciated it greatly. I've been on the commission now nearly 6 years. Many will know that, for better or worse, this is about my last rodeo here. I'll be done in July. We've not seen you before, and many of the people we've seen before our commission, it's their second, third, and in some cases more frequent than that visits. I want to ask you why this time, and the reason I'm bringing it up, why you're here this time. I was a bit concerned on your reference earlier to Mr. Paulson, who, as you know, is engaged in the political process. I think we all strongly feel there should be a bright line dividing legislative, the executive, and the judicial branches. And I know also in our conversation in Esterville, you mentioned some prominent individuals that had suggested that you become involved in the process. Tell me that you're being suggested, to at least to yourself, to become involved in this process by individuals in other branches of the government. Should I be concerned about that as a commissioner?
No, I don't think so. My reference to Craig Paulson was to demonstrate that the role of the Iowa Supreme Court is going to be to also not have a disconnect between this court and the legislature. And I think at one time when the court was sitting in the Capitol building, there was more interaction between the Supreme Court justices and the legislators altogether. And I think that's an important interaction that perhaps has been lost over some time. As I'm hearing it and as I'm down at that Capitol every once in a while, it seems to me like I think we need to restore that relationship that's appropriate between the Iowa Supreme Court and the legislature altogether. So no, I don't see why that would be anything that you should be concerned about for my application here. I mentioned that I was encouraged by colleagues and others who believe, my background and experience would work to serve well as an Iowa Supreme Court justice. And so that's just encouragement by people that I know to run for this position and to apply, and so I did so.
Thank you.
Any other questions down this way? Professor Cochran, being the last person, you see, we don't have to get someone else. You get all the time we have for
And
you.
we can ignore the red light.
Well, some of our prior persons wanted us to honor the red light.
I will
Go
make it
ahead.
brief, not for your sake, but for mine, in case my fellow commissioners say, let's get out of here.
No, take your time and
One of the unique factors you have with your application is you have some good comparative experience here in Iowa, but also in another state in Florida. Are there any areas where we in Iowa compare favorably to the Florida judicial system, and are there any areas where we could maybe learn something from the way they do things down in Florida?
Sure. In Florida, they implemented the electronic filing system about 4 or 5 years earlier than we have. They've got a bigger population base. They had a bigger congestion and budget issues in Florida earlier. And the problems that surfaced as I was dealing with the cases in different county courts, and we have district courts, they call them, some county courts, is that each one had their own rules and their different way of filing electronically into the court system. So every lawyer who's practiced in multi-counties had to learn the entire system in different places. I think the Iowa Supreme Court's approached this right by looking at this, implementing it perhaps too slowly, but I understand the caution behind it because it needs to work. But we need to have one system that's uniform throughout all of Iowa, and I think that's where Iowa has gone. And so that's something that Florida had to learn the hard way. And then I think the other thing that Florida has done, and I don't know that I'm necessarily advocating for this, but there's a much more comprehensive set of civil rules of procedure where they break it down into complex litigation rules. And so if it's a complex case, we have a whole separate set of rules of civil procedure that you're looking at because it's dealing much more complicated cases. The other thing that Florida has done, and I know some judges do it here in Iowa, but it's voluntary, is that they utilize a lot more of the procedure of case management. Here in Iowa, we just check the box automatically on our uniform scheduling orders that basically say, yeah, we'll pick case management if we want it. We'll let the court know. In Florida, it's still there, but it's invoked a whole lot more. And the case management conference, I think, handles and pares down the cases a lot quicker in Florida than we do up here. So typically you can bring up a motion for summary judgment right at a case management conference in Florida, and it can be ruled on dispositively. And I think that's a move that perhaps we could go to here in Iowa as things get tighter and we have bigger dockets and issues to deal with, is the case management procedures. And so there are some of those things that I think we could draw from that we'd benefit from.
Any other questions? Well, Mr. LaVan, I would like to thank you for coming here today, and I would tell you that we have a civil justice reform committee going, and some of the ideas you're talking about may be useful to those folks, and regardless what happens today, whether you're nominated and then appointed or not, I would really appreciate your input to those people, and I think Justice Heck is running it, getting it up, and I think you have some good ideas, and would appreciate your input.
And I'd be happy to volunteer for any of those committees that you would like me to serve on. So yeah, absolutely.
I'll talk to Justice Heck, and maybe we'll get a hold of you and talk to you about some of that stuff. But I thank you very much.
Thank you.
Thank you.